Hello, my name is Dave Siegel. Thanks for joining us. Today we're going to be talking about Chapter 7 bankruptcy and getting out of debt. I'm joined by my co-host, Jesse Barrientes. Jesse, welcome.
Thanks, Dave.
How are things?
Hey, everything is great. We've got a nice fire here for our show, and we're ready to go.
Well, Chapter 7 is the topic. Let's dive right in. What do you want to know about Chapter 7 in a nutshell?
Well, first, do I need a Chapter 7? Because you know what? I see some of these commercials and some of these advertisements that tell me that I can do debt consolidation, and I can just pay them a certain amount of money, and they're going to take off the interest, and they're going to negotiate and stand up for me, and you know, it's going to save my credit. It's better than a Chapter 7.
Well, Chapter 7 is a great way to get out of debt if you have a ton of unsecured debt and you don't have significant assets. A lot of the places that you're mentioning are people who are trying to hone in on people who have debt, but not necessarily get them out of debt, but to extract a little bit of money out of them as they're going down. Most people are not successful in a debt reorganization plan that you see that does not involve bankruptcy because it just doesn't have any strength to it. It's like a voluntary payment plan that the creditors can either accept or not. Some can accept it while others are actually suing the person and garnishing wages. So it doesn't have a lot of strength, where bankruptcy does.
So even if I pay my money to this place, and you know, I mean, I assume that they're working with the
creditors?
The creditors.
Well, they're trying to, and they probably have some creditors in their back pocket that are willing to work with them, but they're never going to get all of them to work with them, and that's the problem. Another problem is a lot of these debt collection reorganization firms collect all of the funds up front before they turn it over to the creditor. So the creditor is basically waiting for a big lump sum payment of a percentage of the debt, and they're not getting dribs and drabs and steady payments each month. So at some point, they lose the incentive to work out this deal, and they want to pursue with collection efforts.
Okay. So you said Chapter 7 is for someone with not a whole lot of assets, right?
Right. Chapter 7 is basically a fresh start.
Okay.
So if someone has significant assets, they're not going to be able to avail themselves of the Chapter 7 bankruptcy laws and eliminate a lot of their miscellaneous debt, because the theory is if you have assets, you could liquidate your assets and pay off your creditors and not file bankruptcy. So bankruptcy is really, Chapter 7 is for someone who does not have significant assets and really needs that fresh start. They've hit rock bottom. They don't have a house with any equity. They don't have a vehicle with equity. And they're just strapped with unsecured debt, which is credit cards, personal loans, medical bills, utility bills, things like that.
Well, what if I don't have any property and any equity, but I make, for one individual, $55,000 a year? Well, what about that? Am I still going to be able to do a Chapter 7?
Most likely not, because
How come?
you make more than the average person in the state. You probably have the ability to repay all or a portion of your debt over the next 3 to 5 years if you got on a budget. Because if you're making $55,000 a year and you don't have any significant assets, where is your money going?
That's the question. Show me the money. Where's the money? I don't know.
Well, you would have to show the court where it's going. And if you can't satisfy the bankruptcy court that you actually have these legitimate expenses, you know, maybe you have a medical condition, maybe you have high utility bills, maybe there's some other reason, student loans, IRS debt. But if you're making $55,000 a year as a single person and you can't substantiate what that income is going towards, then you have a budget issue. And the only way you can avail yourself of bankruptcy is if you don't have that budget issue.
Well, is there is this like kind of a means test? Is there a certain amount of money that I can make before, you know, I'm presumed not to be able to do a Chapter 7?
Yes, there's actually a two-pronged scenario to be able to qualify for Chapter 7. The first is you have to be under the state median for a family of your size. If you're over that number, you still may qualify, but you must satisfy this strict means test, which is a mathematical formula using IRS guidelines for the amount allowed for the expenses. If you still qualify, if you pass that test, you can still do a Chapter 7 if you're making more than the state median. The second prong, though, which is very important, is you must not have available money per month. Because even if you qualify under the median and you still have available money per month, the court is going to require you to do a Chapter 13 and repay your creditors over the next 3 to 5 years.
What if I have $25 available after the allowable minimum expenses?
Well, $25 is probably not enough to sustain a repayment plan over the next 3 to 5 years. But if you have over $166 a month, if you can pay more than 25% of your debt over the next 3 to 5 years, Chapter 7 will not work for you. Chapter 7 really is for someone who cannot afford to pay their bills and they don't have significant income nor significant assets.
Okay, well, let's say then that, okay, I'm going to be eligible for Chapter 7. What's the first step in the process?
Well, the first thing to do with a Chapter 7 is to gather the debts that you have and gather your pay advices. So either your paycheck stub or if you're receiving some kind of Social Security, bring in those statements. And then meet with an experienced bankruptcy attorney who will interview you and see whether or not you qualify for Chapter 7. That's the very first thing you need to do.
Well, what happens? So you said I'm going to need my check stubs. What other kind of documents, financial documents, am I going to need?
Well, you must have filed your most recent tax return.
Well, wait a minute now. Hang on there. What if I didn't make enough last year to file a tax return, so I didn't file one?
Well, if you otherwise don't need to file a return, and you'd have to check with your accountant on that,
okay,
then it would not be required. But the majority of people are required to file returns each year.
What if I filed an extension?
That's fine. An extension is fine.
It's okay.
That's the equivalent of a filing, so to speak.
And if I just didn't file it?
Well, then we're going to have to make you file it.
I'm going to have to go back and file it. What if I didn't file for the past 3 years?
Well, you must file for the most recent year under Chapter 7, and that was made part of the amendment back in 2005. So.
Okay, so I'm going to have to do that. Okay, so I have all my stuff.
Most importantly, though, bring in your bills.
Bring in my bills.
Gather all your bills. Bring in yourself. You'll sit down. You'll do an interview with an experienced bankruptcy attorney who will look and see whether or not you qualify and then make some recommendations.
Well, how about this? What happens if, I have a house, I own a home, and I still want to file a Chapter 7 bankruptcy? Am I going to be able to do it?
It depends. The state of Illinois allows you to keep a certain amount of equity or ownership in property free and clear from creditors.
Okay, well, hang on. Let's back up for 1 second. I'm a little bit confused here, right? And that is, if you're talking about the state of Illinois, I thought bankruptcy was federal.
Bankruptcy is federal, but the amount of property that you're allowed to keep in this state is concerning Illinois law. So Illinois law actually kind of sneaks in there just in terms of how much property you can keep.
So it varies from state to state then?
That's correct.
So if Illinois has X amount of dollars, I could go to another state if I live there and they might have some more?
You could go to another state, but you have to establish residency there. For example, if you wanted to move to either Florida or Texas, and you can wait out 3.3 years, you can protect every single bit of equity in real estate. But you must cross that 3.3-year threshold. But we're talking about Illinois here, and the laws are not that lenient in Illinois. For example, a person in your situation, if you lived by yourself, would be able to protect up to $15,000 of equity in your house. That's not a lot.
That's just for one person?
One person.
If I was married, so...
That would be $30,000.
Okay, and so on. If there were, if it was joint tenancy with 4 people?
Well, you'd still get your exemption of $15,000, but then the court would have to give up the additional equity, pro rata share to the other owners. So you'd be in good shape under that situation unless there was a significant amount of equity.
What if I had a little bit extra in my equity? So it's $15,000 for one person, and I have maybe $20,000. Are they going to sell my home?
Probably not. And the reason being is that a trustee who's appointed by the bankruptcy court would look to see what kind of equity there was. They'd have to take into consideration what it would take to sell that property. You've got real estate taxes, you've got broker's commissions, you have to pay your exemption of $15,000 or $30,000 if it's joint, and then if there's not a whole lot left to administer to your unsecured creditors, the trustee's not going to find it worth his time or worth the creditor's time to administer that asset.
Okay, very good. Well, so what you're saying is, or what I'm hearing is, I can do a Chapter 7 if I have a house. But if I'm under that threshold with respect to my income and with respect to the amount of equity I might have in my home. Is that correct?
That's right.
Okay.
There's a kind of a simple rule of thumb here. If you have a lot of equity in property, whether it be in your house, whether you have an expensive vehicle that's paid for, whether you have significant money in the bank and you're just not paying your creditors, Chapter 7 is not likely going to be successful for you.
Okay, well, so I can save my house with a Chapter 7. So does that mean that, before I come in to see you, I stop paying my mortgage?
If your intention is to keep your property, you're going to continue to make your mortgage payment right through the bankruptcy case and beyond.
What if I'm behind when I come to see you?
Well, there's a couple things you can do. You can try and catch up on your own and still eliminate your unsecured debt, or you can surrender the property, live there until it goes through a complete foreclosure process, and then walk away from it.
So, but that's the only way, if I'm behind on my mortgage, to be able to do a Chapter 7 bankruptcy, is if I'm behind, I can either catch it up or surrender it. Those are the only two options.
Yes, and catching it up could be refinancing, getting a second mortgage, a family member could help you out.
But
You can
Dave-
actually sell it.
Dave, they wouldn't let me. They wouldn't let me with my credit now because I can't afford to pay them behind, so nobody's going to give me a loan.
Well, it's possible that you can refinance after a bankruptcy if you get a co-signer or if you have a family member helping you. Or maybe you'll be able to catch up now that you don't have to pay the high interest security or the high interest payments on the credit cards or the high utility bills or the high personal loan payments. So you might be able to manage and bring your mortgage current if you don't have all your other debt.
Okay, so, but again, that's the only two avenues for me with respect to keeping my house, and that's it.
Yes, most people are able to keep their house because they don't have significant equity. And recently we've seen real estate values drop so significantly that people who did have equity in the past don't have much anymore. So most people can still file and keep their house as long as they continue to make those payments.
Well, what happens if we go the other route and I decide, for example, that you know what, I'm behind, I can't catch it up, I'm just going to stay as long as I can and write it out, but I have equity in my house. I've got at least $16,000 of equity. What's going to happen when they sell it? Am I going to get that money back? Are they going to keep it, or am I just out of luck all the way around?
You're going to get your exemption of $15,000 if the trustee sells your property. You're going to get that off the top.
No matter what. So if they sell it, I'll get my $15,000. I'll get that exemption.
You're going to get a check for $15,000 that you can put anywhere you want.
When they sell it, no matter what.
When they sell it.
No matter what.
No matter what. But that's not a lot of money, Jesse.
Well, how long is it going to take for them to sell it?
Depends on the market. It used to be houses could sell in 2 to 4 months. Now, trustees are not that eager to sell a house because it's just difficult. There's not a lot of buyers.
Okay. So, all right. Now we've decided that we're going to do a Chapter 7, and what about my car? You know, I need a car to be able to get to work, and if I do a Chapter 7, and right now, right, if my credit is bad, and for the folks out there, you know, what am I going to be able to do? I mean, I need to keep my car.
Well, the car is a secured item, just like the real estate. So if you want to keep the car, you continue to make your monthly payment. If you want to surrender the car and get out of the debt completely, then you stop making your payment.
So does the same thing apply with respect to, you know, I'm up to date on it or I'm not up to date on it?
It's basically the same. If you're not up to date on your car, even after filing a bankruptcy, they're going to repossess the car. You have to remain current on houses and vehicles if you want to keep those items.
Let me ask you this question. There's an automatic stay when you file a Chapter 7, right, which prevents creditors from trying to collect on their debt.
Yeah, an automatic stay is like a stop sign that goes up and tells creditors that they cannot take certain actions. They can't garnish your wages, they can't call you, they can't sue you, they can't try and otherwise collect on a debt while the bankruptcy is pending unless they receive court permission to do so.
So they're going to have to go into court and get some kind of an order lifting the stay.
Yes, and that happens routinely on houses and vehicles if a person in your situation is not paying for those items.
Okay, let's ask this question because the thought occurred to me, and I'm sure a lot of people at home, you know, have a similar situation. What happens when you do that? Because people get basically harassed by creditors all the time trying to collect the debt. So what happens? Well, what happens first if I just hire you, but you haven't filed it? You know, is that enough to stop these folks from calling?
Well, under the Fair Debt Collection Practices Act, the minute you hire an attorney and you notify that creditor either in writing or orally that you have representation, the creditor is supposed to go through your attorney for all communications. If they don't, that would be a violation of the Fair Debt Collection Practices Act, and they could be held accountable for $1,000 per violation.
So if they called me, if I sent them a letter and it said, you know, David Siegel is representing me in my bankruptcy case, and I sent them a letter to that effect, and I did it certified, so I've got my green card back and everything else, and I can prove it, and they call me 4 different times, I could sue them for...
Potentially you could. We don't see a lot of that. We see a lot of creditors obeying the law on that.
Okay.
But aren't you tired of being in debt, though? Aren't you tired of not being able to make your payments each month?
Everybody's tired of being in debt, Dave. It's
Isn't that more important than the phone call from the creditor? It's not being able to make your your ends.
Well, not being able to make your ends. However, I'm sure, for the folks at home that, people, there's a lot of pressure. They're trying to make ends meet. They're trying to pay their bills. And, they're getting pressured every time they pick up the phone. There's somebody over there yelling or screaming or trying to collect a debt, and they don't even want to answer the phone anymore.
Sure. Let me tell you about a couple mistakes that people make, though, when they're in debt.
Okay.
And so for our viewing audience, they don't make the same mistakes. You don't want to run up credit cards in contemplation of filing bankruptcy.
Well, why not? If you said I could be able to discharge all this debt, I'm a prime candidate. Hey, you know what I think I want to do? I think I like that nice commercial kitchen stuff, and I think I want some of that stainless steel, the utensils and also the refrigerator freezer, because I think that'd be really nice, especially if I'm not going to have to pay for it.
I think you have all that, don't you?
Oh, well.
Well, here's the deal. Bankruptcy is for an honest debtor. So if you are running up your credit cards knowing you're going to be filing bankruptcy, it's tantamount to fraud. And what the creditor will do is they'll come into court and try and hold recent purchases non-dischargeable.
How recent?
Well, typically there's a 90-day presumption period. If you use your credit cards within 3 months of filing, the credit card company has the benefit of having that debt presumed to be non-dischargeable. Now, you can always rebut that presumption if you can show that you didn't do it fraudulently, but it's kind of obvious if the run-up is so close to filing and you purchase luxury items like plasma TVs, jewelry, big vacations.
Like the stuff in your house.
I don't have any of that. I don't have any of that. I live in meager means, Jesse.
Okay, Dave. Well, hey, if you kind of look at those kind of things, well, we're here in January. We just passed the holiday season here, so say in December, I've charged some things for Christmas presents because I bought you a plasma television, right? And okay, now it's January, February, March. So what you're really saying is that there is that 30-day time period. And a lot of people do that, and again, it's not for an honest.
It comes down to your intent. Buying a gift like that so close to filing, knowing you're already in debt, is not a good thing to do. Again.
And that's different than opposed to maybe groceries.
Of course. Those are necessities. Paying your utility bills with a credit card to keep your gas on.
Paying
to keep
the mortgage
your electric
maybe,
on.
or...
Paying the mortgage as well, yeah.
Or the rent or anything like that.
Yes. One other thing that people should not do, and they do this a lot, unfortunately, is they drain their retirement account, either a 401k, IRA, pension, or other kind of retirement account.
Oh, to pay off the credit cards to stay afloat a little while longer. Why
Yes.
shouldn't I do that?
And what winds up happening, Jesse, is they wind up coming to see me after they've already exhausted all or a great portion of their pension or profit sharing, and then they file bankruptcy. They could have protected 100% of those retirement benefits. They didn't have to touch them. They could have filed bankruptcy and still had all that money in their retirement, and they would have been better off because all they do is drain it now. They file bankruptcy anyway,
Sure.
and there's nothing to retire on. So it's good to talk to a professional before you make any drastic moves. And pulling something out of your 401k to pay Discover Card is not a good idea if you're going to be filing a bankruptcy shortly thereafter.
Well, let's talk about that too, because we have questions about this all the time in terms of, and again, we say sometimes it's too late, when people come in and, hey, guess what? Guess what I just did? And I couldn't keep it afloat. Holiday season was here, credit cards got up there. I refied and tapped that $15,000 of equity I had in my house, and I paid those credit cards, but unfortunately, you know what? The bills are run up again, and I don't have any more equity to tap, and I can't, I can't refi. So, is it a common mistake that you see as well?
This happens a lot. They go for a second mortgage. They go for a line of credit. They use that money to pay debt that they otherwise wouldn't have to pay if they just would have left that equity in their house. Because again, we can protect quite a bit of equity, especially for a joint couple, $15,000, $30,000 worth. And of course, you got the cost of sale, so really you can protect even more than 30. And if you drain it all out of a second mortgage, you wind up paying your creditors. The debt doesn't go away usually. They wind up filing bankruptcy anyway. And now they're sitting on real estate that has no equity, so they're really in almost a zero-sum situation. It's sad.
Not to mention, hey, rolling it in, if you do a refi, not a second mortgage, you roll it in, and now you're going to be paying for those credit card purchases for the next 30 years, or 25 years, or 20 years, or...
That's right.
Or something.
And as real estate values do not continue to appreciate like they used to in the past, it makes it more and more difficult to make that payment or to refinance or to sell. So you're pretty much strapped with that first and second mortgage or line of credit, equity line, for quite some time.
Well, you know, a lot of questions that I get in some of these interviews is that you know, people come in and you know, they have a lot of credit card debt. They just can't shoulder it anymore. They may even be up to date on all of these things, but the burden is just so tremendous and so, you know, extravagant. I mean, they just can't do it anymore. And what they want to do is they want to do the bankruptcy, and they qualify for the bankruptcy, but they want to keep this one card that you know, just for emergencies, just in case.
Right. We refer to that as a security blanket. I want to get out of debt, but I want to keep this one card. Well, why? Because they don't think they're going to get credit again. Well, the truth is...
Can you keep the card?
Typically not.
Why not?
Well, you have to list all the people that you owe money to when you file bankruptcy.
Even Uncle Harry?
Oh, definitely Uncle Harry needs to be listed.
Okay.
His debt needs to be eliminated. But if you have a credit card with a balance, it must be listed. If you have a credit card that has a zero balance on it, you obviously wouldn't have to list it because it's not a debt, but you're probably going to get a letter from that issuer terminating your charging privileges anyway. So don't plan on keeping a credit card if you're contemplating filing bankruptcy. That doesn't mean you won't get credit again. You can apply for a secured card immediately after a bankruptcy, put $250 in a bank account, you'll get a credit card with that much in charging privileges or more, and you'll start to reestablish. And you need to go on a cash basis anyway because you had a budget problem, you had a credit problem, and you were probably using the credit cards when you shouldn't have.
Well, a lot of people also get these pre-approval even after they, you know, while the ink is still hot on their filing of their bankruptcy, and the difference is what? Is the interest that's charged, right? It's
That's
a
correct.
huge amount of interest.
That's correct. There was just a story in the Chicago Tribune recently where a gentleman who has a family kept track of all the credit card applications or solicitations that he and his family received over the course of a year. I think it was about 445 solicitations. So yes, you will get offers for credit again because they can't differentiate between the filers and the non-filers, between the children, between the pets. It's ridiculous.
Oh, so even pets get applications for credit cards.
Even pets.
Oh, too bad you can't get the tax deduction for that, can you?
That's right.
Well, tell me a little bit about the process here, or tell our folks at home here about the process. You know, so you come in, you bring your stuff together, you qualify, you pass the means test. If you're even, you know, even if it goes that way, or maybe you don't need to pass the means test because you're in that income level where it's okay to file a Chapter 7. You've got just the right amount of equity in your house. You've paid up to date on that, but you want to keep your house because you need shelter for your family. You've got your car, you're ready, going to reaffirm and everything else. And
well, the attorney is going to advise you of the certain pre-filing requirements that you need to complete. You must take a credit counseling session.
Oh, wait a minute. In a couple of years, you didn't have to do that.
That's right.
What changed?
Well, the law changed in 2005, and the law made it a little bit more difficult for folks to file.
And who was behind that impetus? Who was behind that push, do you think?
Well, typically the credit card industry. They pushed for this for about 8 years. It was vetoed under President Clinton. Do you remember him? He was 2 presidents ago.
Oh, yeah.
But they finally got it pushed through during the second term of George Bush. And under Obama, we might see some changes as well that will benefit homeowners. They may be able to reduce their outstanding mortgage balance down to the secured portion, to the market value. But that's getting ahead of ourselves. But basically, you need to take credit counseling. It's a 1-hour session typically.
Is that on the, can I do that on the computer? Because I really don't have a lot of time to do anything else.
You can do it on the computer.
Okay.
You can do it in person. You can even do it over the telephone.
What is it for an hour? What is that going to cost me?
Typically $50, and it's a data entry session where you have to explain your income, your expenses, your assets, your liabilities.
So I need my information in front of me.
You need your general information in front of you. And you will get a certificate once you complete that program. That's required before you can file a bankruptcy, and the certificate only lasts for 6 months.
So what if you file it? What if you filed it today and I got my certificate tomorrow?
Your case would be dismissed. In fact, some judges would consider that you didn't ever even file, that it was void right from the beginning.
So then I'd have to pay the fee again to file it again.
You would have to pay the fee again. You'd have to file a brand new petition. You'd have to pay court costs again. You definitely don't want to do too much on your own without the advice of an experienced bankruptcy attorney, because there's so many holes that you can fall into now under the new law that you want to be very careful and follow the advice of counsel.
There is also, so this is a prerequisite, this debt management class.
That's right.
There's also another debt management class that you have to take, which is after you filed your case, but before you get a discharge. Is that correct?
Yes. After the case is filed, you need to submit to a 2-hour financial management class.
2 hours?
2 hours.
Can I do that on the internet?
You can. You can also do that on the telephone. You can do that in person. And it's like Rodney Dangerfield. You're going back to school for a 2-hour class, Jesse.
And what are they going to teach me? Because, Dave, I don't think I'm in this shape because I didn't take a debt management class.
Well, hold on. You just filed bankruptcy. So the government feels you don't know too much about finance.
So
you don't know the difference between 0% and 29%, and you need to be taught that.
So I'm going to have to jump through this hoop anyway.
It's another hoop, basically. It's another $25 or $50 fee. You'll get another certificate that you can hang on the wall. But most importantly, you will now be eligible for a discharge. Because if you don't take that class, your case dismisses without a discharge, and you just wasted all of your time and money
energy,
and got no results.
So if I was smart, I'd be teaching debt management classes, right?
That's right.
Okay.
But the government's smarter than that. They're not going to let someone who hasn't done it for several years all of a sudden open up a business. You had to prove that you were in that business and helping people for a number of years before you get qualified.
Okay. So about the process then. So we go in, we fill out, I give you the information, you complete the petition, volunteer petition for Chapter 7, right? And then it gets filed.
Yes. A notice will go to all the creditors that you have filed for bankruptcy. You will get a notice, and your counsel will get a notice. And then you must appear before a trustee approximately 4 weeks thereafter.
Explain to the folks at home what a trustee is.
Well, a trustee is a person appointed by the bankruptcy court to look over your case, to make sure you don't have any significant assets. If you do have assets, that trustee will administer the assets for the benefit of creditors. Mm-hmm. But 99% of the time, there are no assets, and the debtor, the individual who's filing bankruptcy, will be granted a discharge. And the whole process takes about 90 to 120 days, give or take, from start to finish. And it really is a lifesaver, Jesse, for someone who's struggling with debt. It takes them from being in the red to in the black, mm-hmm. sometimes overnight, with the filing of a petition. And they can rebuild. They can then start saving again. They can then start putting some money away towards their house, towards their vehicle, towards their family, their children.
And so if they basically, after the bankruptcy is done, right, after you get discharged, you said so 3 to 4 months, right, before that happens. So after that happens, I could certainly, if I pay my bills on time for the next couple of years, I can lower my, or improve my credit score, couldn't I?
Yes, eventually your credit score will improve. Obviously, the bankruptcy filing does put a negative on your credit report, but you've got to get out of debt before you can think about rebuilding and improving your credit score and getting a house or a car again. You've got to first get out of the situation you're in. And one last thing before we go.
Sure.
A lot of people come to see me, and they tell me that they have not perfect, but great credit. Their score is this, that, and the other. They've never missed a payment, that kind of thing. And I say to them, look, you're $50,000 or $100,000 in credit card debt. I don't care what your score is. It doesn't matter. You're in a bad situation. So it's not the score that matters so much, Jesse. But basically, start to finish is 4 months.
That's very good. I think it was very informative for our folks at home.
Okay, I hope you found it so, Jesse. And
Well,
remember, Chapter 7 is available if you're having a problem with debts. Thanks for joining us. We'll see you next time. I'm Dave Siegel. Take care.